Hello, everyone. My name is Ariella Wagner. I'm the founder of SunRay Construction Solutions. We help thousands of general contractors, subcontractors, and suppliers secure their lien and bond claim rights. Today, we have the fabulous attorney from Massachusetts, Jessica Murphy, who has over 20 years of experience, who is not only an attorney, she has real life experience because her father was a contractor. So not only do we have an incredible attorney who's going to educate us on a contractor, subcontractors, and suppliers step-by-step guide to continue getting paid, she can explain the pain points because she knows them well. So without further ado, I'd like to introduce the fabulous Jessica Murphy.
Oh, thank you, Ariella. That's a great introduction. I am the daughter of a contractor. I like to tell people I can roof a roof and I can get you paid or sue a contractor who didn't do your roof right. So it's a great background to have as well, because I feel like I really get to know what contractors are experiencing on their sides. So thanks for having me. This is going to be a quick 20 minutes on contractors, subcontractors, and suppliers guides to getting paid. My goal is that you will leave this webinar with some real specific guidelines as to how to get paid, what you can do, and perhaps better some of your practices, because there's no sense in doing the work if you don't get paid for it. So without further ado, welcome to the webinar. If you have questions, you can use the GoToWebinar chat box. I will take the questions and answer them at the end. Please don't include company names in the questions, but you can certainly use my company, contractor, subcontractor, and happy to go over anything that you have there. So first thing we're going to talk about is setting yourself up for success, what you can do before you even get to a payment dispute to make sure that when you get there, you are doing the best that you can to get that better result. So the first thing, this comes along, and this is my absolute favorite acronym, RTFC. Read the freaking contract, please. That is the absolute best thing that you can do for your company to make sure that you get paid. You need to know what's in there. You need to know if it's properly drafted. You need to know if there is a contract or the party's just doing a supply run and somebody says, yep, that's fine, I'll grab those and put them on my account. There's a lot of things, especially in Massachusetts, that you can't do without a contract. Makes it a lot harder to enforce. And there's terms and conditions that you're going to want to know about. So please read the contract. That applies for any paperwork you're getting from the person that you're contracting with. It also applies to doing a periodic review of your contract, making sure that your terms and conditions are updated, that they're going to be the ones that control at the end of the day. And do they have important terms in there like recovery of attorney's fees and perhaps higher than statutory interest? In Massachusetts, if your contract does not say that you can recover attorney's fees, you're not able to, even if you prevail. And also in Massachusetts, it does have a pretty high rate of statutory interest. So when a breach of contract claim, your claim's going to accrue interest at 12% from the date of breach. However, many people will put in 18% interest, which is nice to include at 1.5% a month. It seems a lot less scary that way. But if you have that, at the end of the day, you've now got the ability to recover attorney's fees and 18% interest, which then may make it worthwhile for you to refer a smaller matter to an attorney and make sure you're trying to get as much as possible. It's hard to collect on everything, so if we can maximize your collection on any single one of these, I think you're better off overall. The first point here talks about properly and fully naming the parties in the contract. That is important. Know if you're dealing with a sole proprietor, if you're dealing with a LLC, if you're dealing with an incorporated entity. I have a case going now where there is an LLC who has been doing work as a subcontractor. Turns out that they let their LLC organization lapse by failing to file their annual reports. So during the time period in which this man contracted with my client, he was actually going to be personally liable for that. So we've brought suit against that individual personally, as well as his company, which gives us access to both pools of assets. And that's because we checked the Secretary of State's records after the fact, found out that during the contracting period, his LLC organization had been administratively dissolved by the Massachusetts Secretary of State. This website here is the technical 100%, like if you could click that link, it'll bring you directly to the page on the Massachusetts Secretary of State website where you can search for a corporation. You can search for a corporation, an LLC, you can search by name, and I always think it's a good idea for somebody to do that. Make sure that you really know who you're doing business with. Also, just keeping in mind kind of a little bit broader picture. For example, if you're doing business in Massachusetts with a Dunkin' Donuts, know that Dunkin' Donuts are franchises. If you're doing business with a Cumberland Farms is actually all owned by the same entity. Those are not franchises. So what kind of pool of assets do you really have? You want to know that. Second point here is, are relevant terms included in the contract? Do your terms control what I had mentioned a little bit earlier, just about checking to see what terms are really going to be relevant? Are there things that you have to do before you can get paid? Do you need to submit on a monthly basis? Things of that nature. Dispute resolution terms is a very big one. Choice of law, which state's laws are going to control. If you work in multiple states, think about what you want for your the state's law that's going to control. Do you want it to be the location where the project is happening? Would you like it to simply be your headquarter state's location? Because that's something that's consistent, but you want to know what you're really getting. Jurisdiction, where do you need to sue or be sued? Alternative dispute resolution provisions. Is there a mandatory mediation? Is there arbitration that's going to keep you out of court? One thing it's important to know is you cannot waive your mechanics liens or bond rights in advance. So if that is in a contract, it is relatively safe for you to sign a contract that says that, because they cannot be waived in advance as a matter of public policy. I would much prefer it be struck from a contract, but keep that in mind that that's not enforceable to waive mechanics liens and public project bond rights. And then again, that last point is just about going and reviewing your terms and conditions to make sure that your terms are up to date, that you're getting things completed, purchase orders have information, and if there's job information that it's on there. You'll see later on when we talk about mechanics liens that that becomes important if you need to prove where things went, to make sure that you have your job information, the job location, the full address on there. So next thing to know when your guide to getting paid is what's your leverage? Your contract terms, are they helpful? Can you get attorney's fees and 18% interest? That gives you leverage for someone to say, look, you want to deal with this now, you don't want to put this off 6 months. Do you have an ongoing relationship? Are there supply issues? Are there a limited number of workers? Do you have anything that's going to entice them to want to pay you because they don't want you to walk off the job? And then the other leverage for getting paid is your mechanics liens or bond claims. So once you're in a dispute, once you have a payment default, here is what we're going to do to get you paid. Demand the debt early and often. Make sure you're sending statements, but do make sure they're accurate. Sometimes people will shut off statements after a certain period of time, and there's no problem with doing that. It doesn't waive any rights. But if you can send statements, I would much rather be in a position in court, or I can say the defendant has had notice because they've been receiving statements for 6 months. Every month since it started, they've been receiving statements. So that's very helpful. When you make demand, see who else you can include in the demand. Include your direct contact, include the CFO, you can send it to the CEO. If there's multiple business addresses, which you can find from the Secretary of State's information, send it to them. Send it by email, send it by certified mail. Send it out as frequently and widely as you can. Find out if there's other people who might be interested in knowing about the default. Is there a senior contractor who wants to know? Does the owner of the project want to know? These are maybe ways to put a little bit more leverage to getting you paid. Is there a headquarters out in the middle of the country that should know about you not getting paid, even though you're dealing with a local branch or something like that? And then the next thing is you may need to escalate to an attorney for a demand if it doesn't work for your demand directly. An attorney's demand, I find, is always, it tells somebody that you're ready to file suit. If you're using a local attorney with a good reputation, I think people will look twice at that and say, we don't want to find ourselves getting sued. Let's pay attention a little bit more to this. My goal for you, just so you know, in sending a demand is I want somebody to pick up the phone and give me a call. It is usually always better to try to negotiate a resolution. It keeps your attorney's fees low. It keeps you moving, because I understand that my clients do be involved in litigation that could take a year or two to get to a trial and then work on collection. Your job is to provide labor, sell materials, be in the construction trade. So in that sense, I want to get you back to doing what you do, and I want to get you as much money as I can as early as possible. So here are some options for recovering the debt. One, small claims. Massachusetts, the limit went up to $7,000 a while ago. What I like to recommend is that someone takes a large group of these and perhaps every 6 months or so files 3 or 4 at the same time. If you do file them together, you're more likely to get the same hearing date, and then you can simply be in front of the court on one day, have one, kind of devote one morning to getting this thing done. Once you get a small claims judgment, there is a payment review process, and they do really try to help out the plaintiffs in those cases to try to get you paid. So that's a really great use if you've got a lot of small cases that you can put together. You can't split your claims. So if you have a claim for $10,000, you can't file 2 claims, one for 7 and one for 3. But you can file on 2 different invoices. You can file those separately. So if it wasn't one invoice for $10,000, but it was a $7,000 and a $3,000 invoice, you could file 2 different cases. 2 separate filing fees, and I probably wouldn't recommend filing them at the same time, but you could do that. This next item, the 1099-C cancellation of indebtedness demand, is a variation on what on just sending a regular demand. 1099-C cancellation of indebtedness is a tax form. You would file that if you have decided to give up this debt and essentially forgive it. Once you file that with the IRS, you cannot seek to recover it again. So if you are at the end of your ropes and decides that this is not something that you want to expend any more money to collect, you could send a demand saying, we're going to file a 1099-C cancellation of indebtedness form. It will add the taxes on that to the person whose debt is canceled. And so while that may not make a big difference for a big corporation, if you have a sole proprietor that you're dealing with, that could be impactful because the IRS is going to be a lot more cumbersome in collecting their taxes than perhaps you have the opportunity to be as a company. So again, that's only if you're ready to entirely forgive the debt and never collect it again. You can send a demand saying, I intend to do that. You would need to file that within the first 3 months of the year. So the demand on this type of cancellation of indebtedness is going to be something you want to send the last few months of the year or basically in January. Mechanics lien is a fantastic option for recovering the debt. This is applicable to general contractors, subcontractors, suppliers. There is no level in Massachusetts that you need to particularly be at. Some states require you have to be a first-tier subcontractor, not Massachusetts. As long as you are doing work on a project, you are entitled to get a mechanics lien. Mechanics liens are very powerful. They give you rights that you are not otherwise allowed to have as a subcontractor or a supplier. And essentially what would happen is it puts a lien on the property where the work is being done. And at the end of the day, you would get a judgment that would allow you to sell the property to recover the money that you are owed. Bond claim, that is also a great way to get you paid. You want to be looking to see if there is a bond. There is always going to be a bond in Massachusetts on any sizable public construction project. There may be a private bond. They've become a little bit more popular, but that's kind of one of those things that you'd have to know that there was a private bond out there. If you find that there is a bond available on the project, I suggest getting a copy early on please feel free to use me as the big bad attorney and say, oh, I'm sorry, our attorney says we must have the bond before we proceed with doing the work or shipping the materials. I find that if you wait until there's a dispute, it gets much harder to get the bond, and you do need the bond to know what position you're in terms of the bonding company, and also what the deadlines are, and if there's any special requirements on a private bond as to how you have to exercise that. And then the last option for recovering the debt is to file suit in a simple breach of contract, or if you have a personal guarantee from your credit application, you can file suit on the breach of the guarantee. The nice thing in Massachusetts is you don't need a formal contract in order to sue for breach of contract. There is an implied contract with invoices, with purchase orders, or just simply somebody calling and ordering, or calling and requesting your services, that if you come and do the work, there is an implied contract that they're going to pay you for those services. So regardless of whether a contract exists, you can still file suit. If you are a supplier, however, you should keep in mind that Massachusetts uses the UCC that requires a contract in writing for the sale of goods over $500. So here's just a little bit more information about mechanics liens and bonds, because these are very powerful. Mechanics liens is Massachusetts General Laws, Chapter 254. It does require three main things: a written contract between the parties, which is fairly liberal, but there needs to be some sort of signed writing by the party that you want to charge for this. And that's the party that you've had the contract with, not necessarily the property owner. So you're going to need a written contract, an email that says, if you send out purchase terms, purchase order, for example, if you send out a contract proposal, someone emails back on an email address that looks verifiable, that you can understand where they're emailing you from, and says, yes, let's go ahead. That would operate in Massachusetts the same as a signed contract. As specific as that can be, the better. So if somebody just responds and says, yeah, let's go for it, it would be a great idea for there to be a further email that says, great, we'll take this as your acceptance of contract or estimate number X, Y, and Z, and we'll proceed. But even without that, a written email in response will give you a sufficient amount for a contract. Sometimes we've used invoices as the written contract. We have not yet had that challenged in court. I think it is questionable. But the second requirement for a mechanics lien in Massachusetts is that it's on a private project. Public ones are bonded, so this is only for private work. And the most important thing is you need to initiate your mechanics lien within 90 days of the last date of any work done under the prime contract. And the reason they do it like that, and the way to think about it that I think makes this easier, is assume that you are the foundation guy. The law wants to allow you the same period of time to file a mechanics lien as the person who does the finished painting. So everybody gets the benefit of the last date of work on the last for the last contractor under that prime contract. However, most of the time you're only going to know your last date of performance, so I would keep your last date of performance, make a note somewhere, and when you start getting close, when you're at 60 days, that's the time to really evaluate. You do need the deed reference for the property. You may need to get a title examiner involved, especially if it's a complicated deed, if it's in downtown Boston. Harvard University has a very complicated, and Northeastern have very complicated deeds. So those are things that you need a little bit of time to do. There is a process that you then have to follow for the mechanics lien. There's subsequent filings, but once you get to counsel filing the notice of contract, that first document, the other ones will kind of go quickly. So this is where you give Ariella a call and you say, hey, I need that mechanics lien filed. They can get that on for you. And then from there, your next steps are somewhat laid out in terms of timing as well. Strict compliance with the statute. Eventually, there'll be a lawsuit to enforce, and the judgment is in order to sell the property. The last thing I'll go over here in our last minute or so is the public project bond claim. This is Massachusetts General Laws, Chapter 14929. If you do any work on the federal level, It's akin to the Federal Miller Act. This is what you would call the Massachusetts Little Miller Act. It is required for large public construction projects. What you are looking for as somebody who wants to get paid is that it is a payment bond. There will also be performance bonds, but performance bonds benefit the owner. So a payment bond is what you're looking for. You want to get a copy of that, note the name, note the bond number, note the bonding company, and you want to know who the bond principal is. Because this next point here is that if you do not have a direct contract with the bond principal, you must give notice within 65 days that you have a claim. Otherwise, you're not going to be able to file on that. If you have a direct contract, with the bond principal, which is generally going to be your general contractor, then you can file suit within 1 year. So these are very specific things. There's a whole seminar that we can do on each of these, but just to let you know that they're out there, they're really good options to get paid. They do require strict compliance because they're statutory, and it's a great option as long as you make sure to exercise your rights timely. So with that, I appreciate your time. Hopefully I've given you something that you can look at and either say, I am doing a fantastic job and I have done everything that Jess has said to get paid. If not, perhaps I've given you some suggestions to go out and better your practices. If I can do anything for you, please don't hesitate to reach out. I'm always happy to talk about collections, mechanics, liens, and how to get my favorite people, which are contractors and suppliers, paid. I don't see that we have any questions that have come up yet in the chat, but please feel free, like I said. Oh,
we actually do have a question that came through.
Excellent.
Jessica, you did such an amazing job. I think the greatest takeaway from the state of Massachusetts is really to make sure that you have a contract. When it speaks of strict compliance, which is the question that's asked, the person asked, I work both on residential and commercial projects, and usually I don't have a contract, a written contract. So what do I do? That's what the person is asking. So what do you suggest?
Yeah, absolutely. That's a great question. Residential construction projects in Massachusetts actually are governed by Massachusetts General Laws, Chapter 142A. They are required to have a written contract if it's anything over a nominal amount. So what I would suggest is that you have a Chapter 142A compliant residential contract drawn up. There is actually Chapter 142A, Section 2, tells you exactly what needs to be in the contract. It's the specification of start time, end time, the amount of money, scope of work, etc. That's great. You don't need to have that for, you don't need to have all those same things for commercial projects. And so I tend to find, because the statute is made to benefit homeowners, that I prefer people I work with have a separate commercial contract. Commercial contracts, it's a little bit more, a little bit more rough and tumble, and you'll have then 2 sets of contracts that you'll use. The commercial contract will probably be more beneficial to you because you're not stuck by the requirements of Chapter 142A there. But again, as Ariella said, and you heard me saying, you need to have a contract in order to do a mechanics lien, which is that really powerful tool, especially if you are a lower tier sub or a supplier.
That's really great. So thank you so much. I know that that's an issue for a lot of smaller general contractors. And when I say smaller, they actually might revenue 2-3 million, but they don't follow a business practice. So again, for everyone that's on this call, and everyone who's listening to this webinar, Jessica is a fabulous attorney, and I highly, highly recommend that you have your contracts. Since it's just the beginning of this year, I definitely recommend that you have your contracts reviewed and or written by Jessica to make sure that if God forbid you aren't paid, that you can foreclose without any issues. Otherwise, Jessica, if they don't have these contracts in place on residential projects, it could be considered a fraudulent lien, right?
Well, not necessarily. Yes, on a fraudulent lien because they wouldn't have the ability to lien, but also it's technically a violation of the Massachusetts Unfair and Deceptive Trade Practices Act to have violated this home improvement contractors statute. So although there's no real huge penalties for it, it is one of those things that homeowners will seize on to try to say that they're not going to pay. It doesn't void the contract that you have if it's non-compliant on the residential side, but it just becomes one of those things that the homeowner will take and say, well, I'm not paying you because you violated Chapter 142A, you violated Chapter 93A, and I'm going to go out and get my damages and attorney's fees. You really want to avoid that. And to be perfectly honest, it puts the terms and conditions up front. There are ways to have very simple terms and conditions in an estimate. People sometimes have a small block, which you could use on the commercial side, just a couple of basic terms that you want, but you want to have reliability too. It's very helpful for contractors and suppliers to know what things are going to look like if you get into a dispute. If you do have contracts, always a good idea to take a look at them. Have credit applications re-signed on a fairly regular basis as you look at them and get perhaps new terms. And again, I always tell people, feel free to use big bad attorneys as the reasons that you have to do these things. My attorney tells me I need to update my forms and have them signed. My attorney tells me I need to have this. And frankly, you can also tell people it's a benefit to both of us that we know what the terms of our relationship are going to be up front.
Really fabulous. Well, if anyone has any other questions, Jessica's email's there, her phone number's there. You may have a question that like, oh my goodness, I have this great question and I forgot to ask it, or I really need an attorney. Again, Jessica, we forward all of our customers to Jessica's firm because we trust her and her law firm. So Jessica, you did such an amazing job. Thank you so much for this fabulous webinar that I'm sure is going to help so many businesses.
Excellent. Thanks for having me, and good luck to everybody. Again, you've got my email and phone. More than happy to take a call if there's just even a quick question you have. So please don't hesitate to reach out. Have a great day, everybody.
Have a sunny day. Bye-bye.